I'm leaving.
Okay,
That way I don't have to worry about
Good morning, Ms. Glick.
Good morning.
Madam Hearing Examiner, this is David Killinger. I have a question.
Sure.
I have not been able to find any exhibit from George Smith, who I believe is the first witness today. Was there an exhibit uploaded from him and I'm just not seeing it?
My understanding is that Mr. Padilla will be moving into evidence his exhibits number 22 through 25 as being sponsored by Mr. Smith. And Mr. Padilla can correct me if I'm wrong.
That's correct. Those are the 4 exhibits.
22 through 25?
Yes.
Thank you.
Yeah.
Kim, are you ready to go on the record?
Yes, ma'am, I am. Thank you.
Okay, let's go on the record. We are here today for the 3rd day of the hearing in case number 20-00181-TR-EN. Are we ready to begin with the testimony of Mr. Smith?
Yes, ma'am.
Okay. Kim, will you please swear in George Smith?
Yes, ma'am. Sir, will you please raise your right hand? Thank you. Tight little window there. Do you solemnly swear or affirm under penalty of perjury that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Okay, go ahead, Mr. Padilla.
Thank you. Can you give us your name, please, sir? It's George Smith. And Mr. Smith, are you the designated representative for Rocky Mountain EMS in this matter?
Yes, sir.
Okay. In this matter, the case currently bears the cause number of 20-00181. but it actually involves three different matters that have been consolidated into that number. The first one is case number 19-00298-TR-EN. The second is the second was the numbered 181 case, and the third is 20-00187-TR-EN. Are you the designated representative for each and every one of those three numbers?
Yes, sir.
And have you always been the designated representative?
Yes, sir.
Mr. Smith, do you have the four exhibits in front of you?
Yes, sir.
Okay, let's look at exhibit number 22, if you would, please.
Okay.
That's an exhibit that bears the case number 19-00298-TR-EN, and it is entitled Response to Staff's Petition and Exhibits for Immediate Suspension of the Operating Authority of Running Bear Rescue, DBA Rocky Mountain EMS for safety violations filed October 4, 2019, Transportation Division staff's notice of filing of updated investigation pursuant to the commission order filed October 15, 2019, and other related pleadings. You have that in front of you, sir?
Yes, sir.
Do you adopt that document as your testimony in this particular matter?
Yes, sir, I do.
Move the admission of exhibit 22.
Is there any objection? Mr. Borman, you're muted.
There we go. I do not object.
Ms. Glick, you're muted. Ms. Glick?
Mr. Killinger or Ms. Ashworth, any objection from either of you?
No objection.
No objection.
Okay. RMEMS Exhibit 22 is admitted.
Okay. Mr. Smith, would you look at exhibit number 23, please?
Okay.
That's a document that bears the case number 20-0181-TR-RN, and it is entitled Respondent's Answer to Notice of Formal Complaint and Order Requiring Answer. And the caption pertains to the matter of the formal complaint of Wendy Jo Ashworth against Running Bear Rescue, DBA Rocky Mountain EMS. Do you have that document?
Yes, I do.
Do you adopt that document as your testimony in this matter?
Yes, I do.
Move the admission of exhibit 23.
Is there any objection?
Yes, I do object to exhibit 23. Unlike exhibit 22, which was supported by an affidavit by Mr. Smith, 23 is not. And I don't see anything in here that indicates that it was prepared by Mr. Smith or supported by Mr. Smith in any way.
Mr. Padilla, do you want to respond?
This exhibit, as well as the next exhibit, and I'm mentioning the next exhibit because I presume Mr. Borman is going to have the same objection. This exhibit is submitted because it's consistent with the previous orders of the hearing examiner with regard to what would be the testimony. Generally speaking, the procedure in the PRC hearings is to have a question and answer form of testimony submitted. In this particular case, there is no question and answer form of testimony submitted. This is the direct response to the complaint that was filed by Ms. Ashworth, and the response was not required to be authenticated or sworn to in any particular matter. In my experience in this particular case, every time the hearing examiner has required some sort of affidavit, the hearing examiner has in fact required that be done. That was not done in this case. This is in fact the equivalent, for purposes of this case, this is the equivalent of the written question and answer that would have been taken care of by Mr. Smith. And Mr. Borman questions whether or not Mr. Smith participated in answering this. Mr. Smith has already stated that he has from the very beginning been involved. I can represent to you that he was in fact involved in the preparation of this particular document. And if you deem it appropriate to ask him, then he can be asked. But This is consistent with everything that the PRC and staff have been allowed to do, and it's admissible.
I'm going to overrule the objection. I'll note that RMEMS Exhibit 25, which is signed by George Smith, states that he adopts the answers to the complaints filed by Mr. Killinger and Ms. Ashworth. So I'm overruling that objection. I will give the exhibit the weight that I think it deserves. Mr. Killinger or Ms. Ashworth, do you have any additional or different objections to admission of Exhibit 23?
I would. Mr. Smith was not an employee of Rocky Mountain EMS when myself or Mr. Killinger were working for Rocky. So I don't know how Mr. Smith can attest to anything that me or Mr. Killinger have stated in our complaint.
Mr. Padilla, would you respond to that, please?
That concern is the appropriate subject of cross-examination in this particular matter. As you've already ruled, Mr. Smith has adopted this. That is not an objection that requires not admitting the exhibit. If Ms. Ashworth wishes to cross-examine this witness as to whether he was working and his knowledge pertaining to the time period when she was working or the time period when Mr. Killinger was working, that's, again, I said, the subject of cross-examination.
Ms. Ashworth, I'm overruling your objection for the reason argued by Mr. Padilla. And once again, I will give this exhibit the weight that I think it deserves. Mr. Killinger, anything from you?
I only had a similar objection. That is all.
Okay, so again, if that's the same objection, it's overruled. And RM EMS Exhibit 23 is admitted.
Mr. Smith, would you look at exhibit number 24, please?
Yes, sir.
Mr. Smith, exhibit number 24 is a document that bears the cause number 20-00187-TR-EN. It is entitled Respondent's Answer to Notice of Formal Complaint and Order Requiring Answer. And that document bears the case caption of "In the matter of the formal complaint of David Killinger against Running Bear Rescue DBA Rocky Mountain EMS." Are you familiar with that document, sir?
Yes, sir.
Do you adopt that document as your testimony in this matter?
Yes, sir, I do.
Move the admission of exhibit 24.
Is there any objection?
No objection.
Okay, RM EMS Exhibit 24 is admitted.
And finally, Mr. Smith, would you look at a document that's entitled Exhibit 25? Do you have that in front of you?
Yes, sir, I do.
Okay, Mr. Smith, that's a document that bears the case number 20-00181-TR-EN. It's entitled RMEMS Non-Legal Response. And the case caption is "In the matter of the order to show cause against Running Bear Rescue Inc., DBA Rocky Mountain EMS, semicolon, in the matter of the formal complaints of Wendy Jo Ashworth and David Killinger against Running Bear Rescue, DBA Rocky Mountain EMS, semicolon, in the matter of the petition of the Transportation Division of the New Mexico Public Regulation Commission for the immediate suspension of the operating authority of Running Bear Rescue Inc., DBA Rocky Mountain EMS, to provide an ambulance service." Mr. Smith, do you adopt that document as your testimony in this matter?
Yes, sir, I do.
Move the admission of Exhibit 25.
Is there any objection?
No.
RMEMS Exhibit 25 is admitted.
That's all the exhibits that I have, Madam Hearing Examiner.
Okay. Ms. Ashworth, I allocated to you up to 1 hour to cross-examine Mr. Smith. Do you have any cross-examination of him?
Before Ms. Ashworth begins, Madam Hearing Examiner, I would object to her being allowed to cross-examine in this particular matter. There was an order entered that required only the staff and the respondent to request cross-examination time. Mr. Killinger and Ms. Ashworth were left off of that order, and the hearing examiner recognized that and sent an email to both of those persons asking whether they wish to cross-examine, explaining to them that the deadline that had been set for staff and the respondent would not be the deadline for them, giving them until the next day. Ms. Ashworth never requested any time to cross-examine in this particular matter. The hearing examiner did enter an order. It's entitled Order Setting Order of Examination of Witnesses and Allocating Times for the Examination. With regard to Ms. Ashworth, it says the hearing examiner is allocating 1 hour of cross-examination time to Ms. Ashworth to cross-examine Mr. Smith because it's unclear whether Ms. Ashworth received the hearing examiner's email and invited Ms. Ashworth to request time for cross-examination. Ms. Ashworth missed the deadline and never has specifically requested time, and therefore is not in compliance with the email sent by the hearing examiner, which in this matter would be the equivalent of an order by the hearing examiner, and therefore we object to her being allocated time for cross-examination.
Okay, Ms. Ashworth, would you respond and would you please turn on your video?
Good morning. Yes, ma'am. I did not receive the email. I believe you and I had spoke that you were getting some bounce back from my email. So I did not see those in time. But I can defer any questions I have to questions that Mr. Killinger would have for Mr. Smith.
Well, I'm going to overrule the objection. So Ms. Ashworth, if you have any questions of Mr. Smith, you may go ahead and ask them.
Not real sure what I'm allowed to ask him on. I'm just not sure how he can attest to, Mr. Smith, how can you attest to anything that is in my complaint when you were not an actively working employee of Rocky?
As the authorized representative for Rocky Mountain EMS in this matter and other matters, I've been apprised of the situations that have been going on with the company by Mr. Little and have been keeping track of any pleadings that have been made in regards to any complaints or investigations. So I've been well apprised of what's been happening in the company.
And in July, when the PRC was there at Rocky, you participated in investigation?
Can I ask what year we're talking about, Madam Hearing Examiner? July of what year?
2020?
I was not physically there, no, but I was apprised of the details by Mr. Little.
And what was the reason you were being given information when you were not an employee?
Given information because I was the authorized representative for Mr. Little's investigation matter, case 19-00298-TR-EN. So as the authorized representative, I had to keep track of what's happening pending this investigation.
Well, you're talking about the previous investigation, right?
I am, but it's still an ongoing investigation that has not been closed, so I need to keep apprised of the happenings until said matter is closed.
Okay, so you know of all the deficiencies and complaints that were filed against Rocky. I understand at times you've tried to help resolve those. Were they not all resolved? And if you fix them, why did within a very short amount of time, they go back to being deficiencies again.
Object to the question as being vague. I would ask that the witness be more specific as to what complaints she's making reference to and what deficiencies she's making reference to.
Yeah, Ms. Ashworth, could you maybe split up your question? Okay, thank you. And be
Mr.
more
Smith.
specific.
Okay. How come supplies were not readily available on every single ambulance in the fleet?
Again, objection. There's no time period that could cover the entire 20 years that this business has been in operation.
Yeah, Ms. Ashworth, could you please specify a time frame?
Mr. Smith, between 2018 and 2020, why was there a issue with having supplies on the rigs?
I'm going to object to including 2018 to 2020 in that Ms. Ashworth, as I understand it, is allowed to cross-examine with regard to her complaint and her complaint only. It's staff's responsibility to do the cross-examination with regard to the initial complaint, which is the 2019 complaint. And as I say, as I understand it, Ms. Ashworth's cross-examination should be limited to her complaint only.
Okay, I never said that, and I'm overruling your objection. So, Mr. Smith, would you answer the question, please?
Could I please have the question repeated?
I was asking about why there was an issue with getting or keeping supplies for all the ambulances.
I'm not sure why there was an issue. I consistently received supply requests from the employees, and I met those requests and purchased the supplies that were needed. I can't testify to what happens to them once they go on the trucks if they've been used, but I consistently was ordering supplies to keep these ambulances stocked.
I apologize. I lost audio and video for a minute.
Okay, we have you now.
I'm sorry. If Mr. Smith had responded, I was not able to hear his response.
Mr. Smith, could you repeat that, please?
Yes, ma'am. I'm not sure why there was an issue. During my tenure there, if there was an issue with supplies, I received requests to order them, and I ordered them and ensured they were brought up to Santa Fe. And, if they were used on the truck and nobody let me know what was missing, I couldn't reorder them anytime. But if somebody let me know something was missing, I made sure that I got a chance to get it shopped for and resupplied.
All right, sir. When I started with Rocky Mountain EMS, there were no defibrillators, AEDs on any of the trucks. Were you aware that those were required by the PRC to be on all the ambulances?
Object to the question to the extent that the question constitutes testimony on the part of this on the part of Ms. Ashworth.
Sustained. Ms. Ashworth, you can't give testimony yourself. You can ask him whether he was aware, whether there were any defibrillators on the ambulances.
Okay, I will reword it to that. Mr. Smith, were you aware if there were defibrillators on the ambulances?
I was aware there were no AEDs on the ambulances, but in previous compliance inspections or annual inspections, Mr. James Martinez said, let me know that as long as we have the heart monitors that can serve as defibrillators on the ambulances, that would be sufficient.
And were those monitors required on all the ambulances?
As my understanding, those were required on all the ambulances, yes.
And were they supplied for all the ambulances?
For during my tenure, all the ambulances that were actively running had a monitor on them.
Were there safety issues with trucks breaking down while you worked for Rocky?
I would say there were issues with trucks breaking down, just as any other motor carrier would have an issue with trucks breaking down. It happens. That's why Rocky Mountain EMS employs a full-time mechanic to deal with those issues.
We've lost video on Miss Ashworth again.
I apologize. Being in this hotel room, there's a lot of issues going on. Due to the issue I'm having with the computer and stuff, I'm not going to question Mr. Smith anymore. I will allow Mr. Killinger to do any questions.
Okay,
For the record, Your Honor, I would object to Mr. Killinger being allowed to cross-examine in this particular matter. As I previously explained, there was a deadline set. Mr. Killinger specifically sent an email saying that he understood that you requested him to ask for cross-examination time yesterday, is what it says. And it says, if that's a request and not a hard deadline, I would still like to request whatever amount of time is the maximum allowed for cross-examination. The deadline, as I understand it, was in fact a hard deadline. It was not a request from the hearing examiner, and therefore Mr. Killinger, who via his email admits that he was aware of the email and admits that he didn't meet the deadline. So I would object to his being allowed to cross-examine.
okay, your objection is overruled. Mr. Killinger, I allocated an hour to you for cross-examination of Mr. Smith, and you may begin, and please turn on your video.
All right, thank you, Madam Hearing Examiner. Mr. Smith, when did you begin employment with Rocky Mountain EMS?
August of 2018.
All right, and what is your capacity of employment?
I was the executive assistant to Mr. Edlow.
I'm sorry, I couldn't really hear you.
Yeah,
Could you speak up, please?
and I'm hearing scratching. Is somebody scratching something close to a microphone? Okay, I didn't hear the last answer either.
All right, I'll ask the question again. What is the capacity of your employment with Rocky Mountain?
I was employed as the executive assistant to Mr. Edlow.
All right, and when did this employment end?
April of 2020. Excuse me, it may have been March of 2020.
All right, so is it correct that you were not employed during the time that I was employed by Rocky Mountain?
That is correct.
All right, regarding Exhibit 24 specifically, which is the response to David Killinger's notice of complaint, did you write this document?
I did not.
All right, who wrote the document?
It was prepared by counsel for Rocky Mountain EMS in a response to the formal complaint against Rocky Mountain EMS.
All right, but this is adopted as your testimony?
That's correct.
All right. Is it true that this, which you have adopted as your testimony, is in regard to matters that took place during August of 2020? Is that correct?
That is correct.
And you were not employed during that time, is that correct?
That is correct.
Now, you stated to Ms. Ashworth that your knowledge, because she also said that you were not employed during her time, that your knowledge of the situation that has become your testimony came from Mr. Little as he was apprising you about what was happening during those matters. Is that correct?
That's correct, along with any pleadings that have been filed, I've been keeping track of.
All right. So is it correct that you have no personal firsthand knowledge of any of this information and that everything that you have has come from Mr. Little?
That is correct.
Thank you. All right. Regarding Exhibit 24, Segment 1, you say that I sought to intimidate or even blackmail Mr. Little. Do you have any evidence of this?
Just the long string of text messages that were sent demanding apologies and payment that was been provided.
All right. Is it your testimony that demanding payment for work that I had performed is considered blackmail or any excessive amount of money?
I would say if you're based on your messages that if you don't pay me, I will, quote, not to be direct, if you don't pay me, I will make complaints. I would say, yes, that is blackmail.
All right. Is there anywhere in my text message that says if you don't pay me, I will make a complaint?
I don't know particularly. That's I said I wasn't quoting directly, but that was what I was told.
All right. Also regarding that segment, you said that the blackmail was for an exorbitant amount of money. Do you consider the earned wages as promised by Mr. Little to be considered an exorbitant amount of money?
I would say no if that was the agreement on your wages.
Thank you. All right. Regarding that it be in return for a promise to not file any kind of action, do you consider that my wages are in return for a promise instead of in return for my work that I had performed?
It was relayed to me that the money was, requested immediately by a certain deadline, or you would make a complaint, and that would, I'd say, intimidate anybody. If you were paid the wages based on pay schedules, then yes, but making a hard deadline demand for a time, then I would say that could be taken that way.
Are you familiar with the pay schedule of Rocky Mountain and that the date scheduled for the deadline was the normal payday?
I'm not intimately familiar with what that date would have been based on, I'm not 100% sure what their pay periods may have changed after I had left.
All right. Are you familiar with the threats of withholding pay that I was delivered by Mr. Little prior to having sent that text message?
No, I'm not.
Objection, there's no allegation that there were threats of withholding pay. And furthermore, the commission has already ruled that the commission has no jurisdiction with regard to pay matters.
Sustained.
All right. Mr. Smith, you said that you received that information regarding the promise from Mr. I'm sorry, you said you received that information. Was that information received from Mr. Little?
Yes.
Thank you. All right. Segment 2 of Exhibit 24. Regarding me waiting 5 weeks to file, Mr. Smith, are you aware of any time limit in regard to me filing a formal complaint with the PRC?
No, I'm not aware of any time limit.
Thank you. All right. Regarding segment 8, you scroll down a little bit. Bear with me here. So again, with segment 8, this is in regard to my time with Rocky Mountain EMS. Is it correct that you have no firsthand knowledge of this and all of your knowledge has come from Mr. Little on this matter?
That is correct.
All right. But you are adopting this as your testimony?
Yes.
Thank you. All right, Mr. Smith, you state that furthermore in paragraph 5 of his typewritten statement, complainant states, I functioned as trainee, driver, paramedic, supervisor, dispatcher, marketer, and director. Complainant statement that during these short 3-week period, he developed an intimate familiarity with our EMS operation while fulfilling all of those extensive and unbelievable job requirements is obviously extremely exaggerated, as no person can become intimately familiar with a business operation as complainant asserts in such a short period of time. Mr. Smith, do you have any evidence or knowledge that I did not function in those capacities during those 3 weeks?
I have no knowledge that you did not function in those capacities, no.
Thank you. Mr. Smith, do you have any knowledge of what intimacy I developed with RMEMS during that time?
I don't have any knowledge of what level of intimacy that you had gained. Rather than stated that it seemed highly unlikely to become that familiar with an organization in that short period of time, trying to wear that many hats.
Right. And is this your personal opinion?
That is my opinion, yes.
Thank you. And that opinion was formed when you were not employed at the same time that I was, correct?
That is correct.
Mr. Smith, have you witnessed any of my work in the past?
No, I have not.
Thank you. Bear with me, I'm going through the exhibit here. During segment 9, this is regarding my resume. Towards the end of this segment, you said, given complainants' obvious exaggerations and the impossibility of complainants working full-time in 2 different states at the same time, as well as competing around the country and world during the same period, complainants' credibility is non-existent, or at least must seriously be questioned and scrutinized. So, Mr. Smith, why do you consider this to be an exaggeration?
Essentially, it was just based on, it's hard to be 2 places at once and maintain these jobs. I do understand that during your testimony earlier in this proceeding that you have given explained your situation of employment. So it does seem feasible at this time.
So it is, are you saying that it no longer seems to be an exaggeration?
It wouldn't seem to be. If the statements you gave are correct, then yes.
Is your statement that my credibility is non-existent based on the aforementioned exaggeration?
I would say yes.
So is it your testimony at this point that your questioning of my credibility should be stricken from the testimony?
I object to the form of the question. Stricken from testimony is not an appropriate.
I'll amend the question. Is it your testimony at this point that you no longer have any question on my credibility as a witness?
That is correct.
Thank you. All right, Mr. Smith, segment 12. You say the concept that a certified EMT is incapable of performing EMT functions without training makes no sense, and could even be said to be laughable. Mr. Smith, are you EMT trained?
I was formerly EMT trained, yes.
All right, where did you receive your EMT training?
At Joint Base San Antonio, Fort Sam, Houston, Texas.
All right. During this time that you were trained, what was the time frame on that?
That was between March and June of 2014.
All right. Mr. Smith, did you ever function as an EMT in a work capacity?
Yes, I served as a EMT with the United States Army.
All right. Have you ever functioned? I'm sorry, you said your training was through the military, correct?
That's correct.
Have you received any civilian EMS training?
Part of my military training did require certification by the National Registry of Emergency Medical Technicians.
Thank you. During your training in EMS and becoming EMT certified, did you receive any hands-on training with patients?
We did a lot of hands-on training with simulated patients, yes, but no live patients.
Okay.
Well, I mean, not, I guess the simulations were on live people, but rather not with legitimate illnesses, rather training scenarios.
All right, and this training was performed prior to the pandemic, yes?
Yes.
All right. Are you aware that during the pandemic that a lot of EMT training programs were modified, as I believe I mentioned in my formal complaint?
I became aware of that during your testimony, yes.
Okay. Is it your testimony that if an EMT has received training and certification without actually touching a live patient, that they should not receive any training once they go on the job?
No, I believe they should. I was unaware of any EMTs being hired that didn't have any of that experience.
Thank you. And this is similar to a previous question I asked. Mr. Smith, did you ever, outside of your training, did you ever work as an EMT in the civilian field?
No, I did not.
Okay. Are you familiar with any of the training programs that any EMS agency has?
Could you expand on that question? It's very vague.
Is there any EMS agency that you are familiar with their training program?
I object. I'm not sure what EMS agency means.
Any EMS agency. Is there any EMS agency with which you're familiar with their training program?
Again, I object to the use of the phrase EMS agency is unclear. Is he talking about an agency of a government? Is he talking about a specific business?
Sustained,
EMS
could you be more specific, please, Mr. Killinger?
Emergency Medical Services. The abbreviation is EMS. I'm going to say any ambulance company in the civilian world. Are you familiar with any civilian ambulance companies training program?
No, I'm not.
Thank you. Mr. Smith, you also mentioned in the same segment 12, the concept that a properly licensed driver cannot properly drive an ambulance without prior experience and training falls within the same category. So, Mr. Smith, is it your testimony that someone who has a driver's license does not need additional training to drive an ambulance?
It depends on the situation. Yeah, I believe that there should be additional training, but based on my understanding of the rules, you don't need any other certifications to drive an ambulance unless you have a patient in the vehicle. I mean, anybody can buy an ambulance off the side of the road and drive it around town.
Mr. Smith, in regards to this question, are you referring to the people who were licensed and operating as drivers by RMEMS?
I'm referring to just anybody. I mean, yes, I agree that there should be training when handling patients and driving, and it falls within that safety category.
And Mr. Smith, are the drivers that are employed by RMEMS responsible for driving with a patient in the ambulance?
Yes, they are.
So is it your testimony that if they are responsible for driving with a patient in the ambulance, that they still do not need any additional training if they are a licensed driver?
I would say they do need training, yes. They may not need prior experience, but definitely they need some sort of training.
But your statement and your testimony says prior experience and training. Is that correct?
That may have been a clerical error.
So is it your testimony then that they do need additional training?
I would say yes.
Thank you. Regarding segment 16, you state furthermore, had complainant provided any training during the 3 weeks he was employed by respondent, there would be no complaint with regard to the subject matter of paragraph 10. All right. Mr. Smith, are you aware of what training I performed and provided to the employees during the period of my employment?
I have no personal knowledge, but based on the information.
Thank you. That's enough. You said you had no personal knowledge. Is that correct?
I object to the interruption. This witness should be allowed to complete his response before another question is asked.
Sustained. Mr. Killinger, I allow some follow-up or elaboration. So,
All right. As a point of clarification, is there a point at which I am allowed to cut off a witness? Considering that I have an hour time limit.
I would object to response to that question. It's very generalized, and I think it pertains to the specific issue that is before the hearing examiner at that point in time.
Mr. Killinger, I use my discretion. So, Mr. Smith, the last thing I heard you say was that you didn't have any personnel knowledge, and I'll allow you were going to continue. I'll allow you a brief follow-up to that.
Thank you, ma'am. Based on the information that I was given, that the training that was provided was minimal, and that not sufficient to what believe what Mr. Killinger was hired for.
And Mr. Killinger, I just wanted to ask you, when you're reading from Exhibit 24, if you could slow down when you're for the court reporter, please.
Yes, ma'am.
Thank you.
Mr. Smith, you said that you were told the information that you received was that my training that I provided was minimal during that time. Is that correct?
That is correct.
All right. And from whom did you receive that information?
From Mr. Rule.
Thank you. Madam Hearing Examiner, how much time do I have left?
39 minutes.
Thank you. I'm also referring to the segments of my complaint that are referred to by number here.
Oh, is Mr. Killinger referring to his complaint or to the response to his complaint?
I am updating you as far as what I'm doing right now, since I'm not actively asking questions. Regarding segment 19 of your exhibit 24, Mr. Smith, it says any issues with respondents' ambulances, because you denied the various mechanical and equipment issues. Any issues with respondents' ambulances would certainly have come to light during PRC Inspector James Martinez's annual inspection, which occurred on July 14th, 2020. Mr. Smith, are you saying that it is denied that any mechanical or equipment issues have taken place after the inspection of any given vehicle?
It's possible that it could happen at any time, but based on my knowledge that when we have those issues, the vehicles are then taken to the mechanic for servicing.
All right, you said this was based on your knowledge, and where did you receive that knowledge?
Just in my knowledge, working with the company, that anytime that we had any deficiency with the vehicle, especially with heat and air conditioning, we took it to the mechanic for service.
And were you working with the company during the time that I was employed there?
I was not.
All right, so regarding this particular complaint, where do you get your knowledge from?
Which particular complaint is Mr. Killinger asking about his complaint?
So from my formal complaint and the time of my employment there, Mr. Smith, where are you getting your knowledge as far as the maintenance during that time?
Just my knowledge is based on my knowledge of the company and how the maintenance schedules work. Generally, if there's an issue, it gets taken to the mechanic. I've never seen an instance where it hasn't been.
And are you familiar with all of the maintenance operations of Rocky Mountain EMS from the start of your employment until today?
I'm not aware of all of the maintenance. No, I'm aware of, that there's general maintenance done on the trucks, and if there's anything immediate issues that happen, the mechanic is called to come service these vehicles, or they're taken out of service until the time that he can handle that.
So it is your testimony that the maintenance has always been exactly as it should.
As far as I know, yes, the mechanic does his best to take care of all these vehicles.
Thank you. All right, you said furthermore, it is incomprehensible. Let me slow down. Furthermore, it is incomprehensible that a receiving entity, which had a patient complain of being transported for an hour in, quote, a hot box, would not have reported that complaint to appropriate regulatory authorities. Mr. Smith, when you say receiving entity, are you referring to the receiving hospital?
Or any receiving facility, yes.
All right. When you say that it is incomprehensible that the receiving facility would not have reported that to an appropriate regulatory authority, are you familiar with the receiving facilities policies on reporting these things?
No, I'm not. I just, if this were an issue like you're stating it is, any healthcare provider would really try to bring that to light, especially in dealing with these hospitals. They want to ensure the best care is for their patients.
So, Mr. Smith, you're saying that any healthcare provider should bring this to light. Is that what you just said?
Yeah.
Would you classify me as a healthcare provider, as a paramedic that was caring for that patient?
I would, yes.
Does it sound like I am bringing this problem to light?
I believe it. So, yes.
Thank you. Regarding segment 24, you refer to paragraph 28 of my complaint, which is regarding transporting patients in truck 67 without having a PRC inspection first. In your segment 24 of exhibit 24, you say that it is impossible for complainant to be aware of the status of the vehicle during a time period when he was not employed by a respondent. Mr. Smith, is this a denial of the accuracy of my complaint and the validity, or is it a denial that I could possibly know that it was a problem?
That's saying that essentially the speculative conjecture, as said in this, if you weren't there to.
Excuse me.
The court reporter's waving at us.
I didn't hear any of your answer. When you put your head down, the microphone looks like it's this way. Oh,
Put it a little
there.
closer. Is that better?
Yes, thank you.
Apologize for
Right
that.
That's a lot easier to hear. Thank you.
So, Mr. Smith, would you repeat your answer, please?
Yes, ma'am. No, as stated in the response, it's speculative conjecture that you'd have personal knowledge of anything happening if you're no longer employed there. Rather, it would be something that somebody told you, as you've raised in many of your concerns to me.
All right. So to sum up your response, would it be accurate to say that your response in segment 24 is based on it's saying that I could not have any knowledge of this problem? Is that correct?
That's correct.
So this segment 24 is not denying the validity of that complaint. Is that correct?
Objection, argumentative.
Overruled.
I can't say whether or not it has any validity or not because, again, it's hearsay. I can't see any way you would know that if you're not personally there, you're being told. So I couldn't answer whether or not it's valid or not.
Thank you. In segment 27 of your exhibit 24, Mr. Smith, you say that in addition to all of the above, respondent affirmatively states that complainant's formal complaint violates complainant's contractual obligation to mediate as required by the mediation agreement attached hereto, marked exhibit B, and by reference herein made a part hereof. Mr. Smith, are you familiar with that mediation agreement?
Yes, I am.
All right, could you explain to me how I violated that agreement?
No, the mediation agreement does state that you are required to mediate any irresolvable disputes involving your employment, discharge, benefits, compensation, promotion, demotion. Excuse me, I'm sorry, I'm reading so fast.
Yeah, please slow down, Mr. Smith.
Oh, I apologize. I caught myself as I was doing it. That any irresolvable disputes involving your employment, discharge, benefits, compensation, promotion, demotion, job description, responsibilities, assignment, and or discipline to a mediation by a mutually agreeable third party.
Thank you. Now, Mr. Smith, based on what you just read during that segment that you just quoted from the agreement, does it say irresolvable disputes?
Yes, it does.
All right. Did you hear my testimony earlier in the week that my dispute with Mr. Little regarding compensation was resolved?
Yes, I did.
So if it is not an irresolvable dispute and it was resolved, does it fall under that mediation agreement?
I would say in regards to compensation, yes, but you talk about all the safety issues which have been involving your employment with Rocky Mountain EMS, and I do believe that would violate the mediation agreement.
So does it say anywhere in that segment that you just read that any complaint is irresolvable and any complaint has to go to mediation?
It says any irresolvable disputes must be mediated. Yes.
So irresolvable disputes, yes.
Yes.
Thank you. All right. And does it say anywhere in that mediation agreement that I am not allowed to file a formal complaint with the PRC regarding regulatory matters?
It does not.
Thank you. So is it still your testimony that my complaint, my formal complaint to the PRC violates my mediation agreement with the company?
I would say that still falls under the realm of your employment with Rocky Mountain EMS, which should have been mediated.
Thank you. Madam Hearing Examiner, I have no further questions.
Okay. Mr. Borman, you're up next and you have 2 hours.
Thank you. I hope to be much briefer than that. Good morning, Mr.
Madam
Smith.
Hearing Examiner, before we begin, the witness has just told me that he needs to use the restroom. Could we take a quick 5-minute break to allow him to do so?
Sure.
Thank-
So let's come back at 10:05.
Thank you.
Kim, did you want to?
No, I was just, that's my way of showing my hands aren't on the keyboard.
Oh, okay. Okay, Mr. Borman, you may begin.
Thank you. Good morning, Mr. Smith.
Good morning, Mr. Foreman.
Mr. Padilla introduced you as the designated representative of RMEMS. What does that mean?
I've just been designated and authorized to act on behalf of Rocky Mountain EMS in these proceedings.
Okay, but you don't currently work for Rocky Mountain at this point. Is that correct?
That is correct, sir.
Okay. And it looks like you were with Rocky Mountain from August 2018 until April 2020. Is that correct?
That is correct, sir.
Okay. What do you do now?
I work in association management for a nonprofit organization that deals with commercial real estate.
Okay. But you're still also, I guess, appearing on behalf of Rocky Mountain as well, right?
That is correct.
Do you have a contract with Rocky Mountain?
I don't have a contract in place, rather just an agreement to compensate me for any time that I may miss from my other job.
Okay, so you are getting paid for what you're doing for Rocky Mountain.
Yes, sir.
Okay. Mr. Padilla also said you have always been the designated representative. I'm not sure I understood what that meant.
Just that throughout these proceedings, I have been the representative that's been designated to appear on the behalf of Rocky Mountain EMS.
Okay, so you've always been during the pendency of these proceedings.
That's correct, sir.
Okay. When you were with Rocky Mountain, what was your role?
I was the executive assistant to Mr. Ed Little.
What are the obligations of that role?
Just helping him keep apprised of the day-to-day operations and assisting him with any tasks that he may need completed in that capacity.
Did you have supervisory obligations as part of that role?
Very limited. Any supervisory obligations I would have had were just assisting in making the monthly schedule and checking in with people and while they were at work, but no designated telling people what they needed to do now.
Okay. So do you communicate regularly with, well, let me back up. I presume that you've been retained by Mr. Little on behalf of Rocky Mountain. Is that correct?
That is correct.
Okay, and Mr. Little is he the president of the company or what's his title?
President, yes, sir.
Oh, okay, and does he own the company? Is that how it's, if you know?
Yes, sir. He does own the company.
Okay. And, okay. Is Rocky Mountain concerned about the possible outcome of this proceeding?
I believe so. Yes, sir. I'm sure any other business owner would be concerned about the outcome.
Well, if they're concerned about the outcome, how come Mr. Little is not appearing in this case?
Object. That's an inappropriate question. That's a matter of attorney-client dealings and is privileged.
I don't see how it's possibly privileged. I'm asking this guy a question about, why his employer or ex-employer isn't appearing in this case.
Determinations as to who will be a witness and who will represent are based upon the advice of client, and that is communications with the client, and that is privileged information.
So are you saying that there's a legal concern about having Mr. Little appear in this case?
I'm not testifying, Madam Hearing Examiner. I am objecting to the question as to why Mr. Little is not here.
So I'm sustaining the objection to the extent it would require the divulging of attorney-client communications, but I'm allowing it to the extent that Mr. Smith knows why Mr. Little isn't testifying. And I was going to ask this question myself. Given that it appears that Mr. Little is the one with personal knowledge of the facts. So if you can answer that question, Mr. Smith, I'm directing you to answer it.
Ma'am, I have no personal knowledge of the conversations that Mr. Padilla and Mr. Little may have had concerning his testimony in this matter.
Mr. Smith, do you know how many ambulances Rocky Mountain has?
Can I ask for clarification? Are we talking about at the present time, or because this spans from 2017 to the present?
Well, the question was asked as of the present, so I guess let's start there.
I'm unsure of the exact number. I know that some more units had been purchased after my departure. I'd say approximately between 10 and 15 units, but not all of them were operational or put into service.
Okay, and how many did they have during the period that you were employed at Rocky Mountain?
I'd say he started with, when I started, there was maybe 6 or 7, but Mr. Little was constantly seeking to improve and add to his fleet.
And so it sounds like you believe there may be more now, but you don't have any personal knowledge of that. Is that correct?
I know there hasn't been any other acquisitions since December, but I don't have an exact number of how many there are.
Okay. Do you know where Rocky Mountain stations its vehicles?
Rocky Mountain stations any operating vehicles generally at their Santa Fe operating base.
So they're all stationed in Santa Fe.
When they're operating currently, yes.
Okay. Do you know how many of Rocky Mountain's vehicles are currently operating?
Right now, there are 0 vehicles operating since Rocky Mountain authority is suspended.
Okay, that was an inartful question. I apologize. Do you know how many vehicles would be operating if Rocky Mountain were able to provide service right now?
I believe 3 or 4 is what is kept during in an operating rotation.
Okay. From when you were with Rocky Mountain, did they keep the PRC apprised as to any vehicles that might be out of service at any given time?
We did send lists, and I will say that we probably weren't the best at being on top of it in every instance, but we did try to keep intact or in communication.
Mm-hmm. So if I were to check the records of the PRC Transportation Bureau, I'd see reports from Rocky Mountain about vehicles taken out of service.
Periodic ones, like I said, it wasn't the best in keeping track of it, and I'll testify to that.
Okay, thank you. I have no further questions for this witness.
Mr. Smith, I have a few questions for you.
Yes, ma'am.
Why did you leave your employment position with Rocky Mountain EMS?
I left because an opportunity became available for me to take a position that would financially compensate me better and help me take care of my family.
Okay. Do you know whether someone was hired to replace you as executive assistant to Mr. Little?
Yes, ma'am.
And who was that?
I don't remember her name off the top of my head, but she She succeeded me prior to the hiring of Miss Ashworth.
You said that you are the designated representative for Rocky Mountain EMS. Who designated you to represent Rocky Mountain EMS?
Mr. Little,
Did you work at Rocky Mountain EMS at the same time as Wendy Ashworth?
I did not, ma'am.
Did you write RMEMS's Exhibit 23, which is the response to Miss Ashworth's complaint?
I did not write that complaint, ma'am.
You mean the answer?
Yes, ma'am, excuse me.
And who did write it?
That was drafted by council.
Okay. Given that you were not working at the same time as Miss Ashworth, do you have personal knowledge of the allegations in her complaint that relate to when she worked there?
I do not have personal knowledge, but I do have knowledge that has been relayed as I was in constant contact with Mr. Little on the day-to-day activities that were going on.
So your knowledge came from Mr. Little?
Yes, ma'am.
At the December 11th, 2020 hearing, Richard Austin testified on behalf of Rocky Mountain EMS. Is he still, and he said he was working at that time as a consultant and director of operations for Rocky Mountain EMS. Do you know whether he is still working for Rocky Mountain EMS in either of those positions?
No, ma'am, he is not working for Rocky Mountain in either of those capacities.
Thank you. That's all the questions I have. Mr. Padilla, you have up to 10 minutes if you have any redirect.
Mr. Smith, you just stated that Mr. Austin was not is not working in either of the capacities with Rocky Mountain EMS. After the hearing of December 11, 2020, which resulted in the company being shut down, is anybody working for that company at this point in time, or since the suspension occurred?
To my knowledge, they kept a couple of people on that dealt with outstanding billing, that are not EMT personnel, but just office personnel. But I believe they've been laid off since.
Okay. Mr. Smith, you were asked a question by Mr. Killinger, and the question essentially was, are you familiar with any training program of any civilian company? And you said no. Did you understand that question to include any familiarity with training program or training done by Rocky Mountain EMS?
It was my understanding that the question was any program outside of Rocky Mountain EMS, but not referring directly to Rocky Mountain EMS.
Okay, so do you have any familiarity with regard to training at Rocky Mountain EMS?
Yes.
And what is that familiarity, sir?
Certainly we go from hire. We do put people on the trucks and they are trained. It's essentially on the job training.
Mr. Smith, you were asked a number of questions with regard to the fact that you were not employed by Rocky Mountain EMS during the time that either Miss Ashworth or Mr. Killinger was employed there. Did you serve any function in assisting in the operation of Rocky Mountain EMS? For example, with regard to ordering of supplies?
Yes, Mr. Little did reach out to me periodically, and I assisted him with ordering medical supplies to help keep ambulances stocked. And he occasionally would consult me on matters that he just wanted to talk about.
Okay, and do you have any recollection as to whether or not you assisted in ordering supplies during the time period from May of 2020 through August of 2020?
Yes, I did.
And did that occur, to the best of your recollection, a single time, or was that a somewhat, or did it occur more than once?
I believe it might have been more than once. I couldn't be sure. We did order a lot of supplies in bulk, so it may have been the single time. I'm not 100% sure.
Do you have any idea why Mr. Little would be calling you a non-employee and asking you to order supplies for the company?
Just based on my history and vendor contacts that I'd made during my employ to help him, have dollars make sense and take care of the back end of the company as well as the patient side.
When you say have dollars make sense, what do you mean in connection with the ordering of supplies?
Generally, in past experiences that requests would be made directly to Mr. Little about purchasing supplies, or and he would direct it to me to reach out to vendors and get the pricing, because while this is a patient care services, is also a business that has to turn a profit in order to pay its employees and continue to purchase new equipment to take care of its patients.
Are you personally aware of any circumstance in which supplies that were required to be on Rocky Mountain EMS's ambulances were not ordered when they were requested to be ordered?
Generally, no. I'd say no. If somebody asked for supplies, we would do our due diligence, find out, make sure that we were ordering the right stuff that was compatible with our equipment, and then place the orders.
In this particular instance, when the original petition was filed on October 4 of 2019, and then Rocky Mountain, there was a follow-up investigation, and ultimately there was a suspension. Did that suspension in part take place because of findings in the follow-up investigation of lack of certain supplies?
I believe so, yes.
And did you take action? You were still employed with Rocky Mountain at that point in time, correct?
Yes, I was.
And did you take action with regard to ordering those supplies and dealing with all of the lack of supply complaints that had been documented by Mr. Martinez on behalf of the PRC?
Yes, I did. If somebody let us know, whether it be employee or investigators from the PRC, that we were lacking something, I took action to get it replaced and stocked.
And did you provide proof of your having taken those actions to Mr. Martinez?
Yes, there were times that I'd sent emails to Mr. Martinez with the invoices from the purchases that still needed to ship, and I believe he'd seen them when he'd come out and re-inspect.
And were those actions on your part to satisfy the concerns of Mr. Martinez? Did they ultimately result in the commission reinstating the certification of Rocky Mountain EMS?
Yes, sir.
That's all the questions I have, Madam Hearing Examiner.
Mr. Killinger and Ms. Ashworth, would you please put your video back on? Mr. Killinger, are you there?
Sorry, my internet cut out for a moment. What did I miss? I had
Oh,
about 60 seconds out.
I was just going to say that I allocated 10 minutes among you, Ms. Ashworth, and Mr. Borman. If you have any follow-up to my questions or to the questions that Mr. Padilla just asked on redirect. So do any of the three of you, if you have any questions, would you raise your hand? Okay, go ahead, Mr. Killinger.
All right, Mr. Smith, you said that you have been, I'm I'm sorry, looking at the wrong line here. You said that you do have, when Mr. Padilla questioned you, you do have familiarity with the training program at Rocky Mountain EMS. Is that correct?
Yes.
All right. How do you have familiarity with that program?
Just based on my knowledge of the, of working there and, hiring and assisting, helping hire employees to go up and work.
Mr. Smith, did you personally receive any street crew training for any of the EMT or driver positions at Rocky Mountain EMS?
I received driver training.
Okay. Did you receive any EMT or higher training at Rocky Mountain EMS?
I did not receive that training, no, as I was currently no longer licensed.
Were you involved with assisting with the training with anybody that was driver or higher?
I wasn't involved in assisting with the training, no.
So where does your knowledge come from as far as what training they actually receive?
My knowledge is based on what the paramedics told me was being trained.
All right, thank you. Now, when Madam Hearing Examiner asked you a question about how you have knowledge of what you're testifying on, your response was that you have, and I quote, constant contact with Mr. Little on the day-to-day goings on. Is that correct?
That's correct.
All right. When you were questioned by Mr. Padilla, as far as your duties with the company, you responded that you have, and I quote, occasionally, that Mr. Little has, and I quote, occasionally consulted you on matters that he wanted to talk about. Is that correct?
That's correct.
Thank you. So which would you say is more correct, that you have constant contact with Mr. Little or that he occasionally consults you?
I have constant contact with him just on operations, but he does occasionally consult with me on questions on regulatory or supplies.
So would you say that you are a consultant for Rocky Mountain EMS?
I wouldn't say necessarily a formal consultant. I do help out, but I'm not a formal consultant, no.
All right. Do you still conduct ordering of supplies? If Rocky Mountain was in operation today, would you still be conducting ordering of supplies for Mr. Little?
If he asked me to, I would.
So that is a function that you have continued since your employment. Is that correct?
Generally, yes. Just like I said, it's just helping him out.
Okay. And do you have any personal knowledge of the state of equipment and supplies and readiness of the vehicles, or are you relying on information from other people?
I've been, while I was there, I had personal knowledge, but after I left, I rely on the information that I'm given.
So do you have any knowledge that the equipment and supplies that you ordered are sufficient to keep all the vehicles in compliance, or are you only ordering what you are told to order?
No, the supplies that I ordered for Mr. Little are based off of the checklist that has been provided to us by Mr. Martinez in the PRC rulebook, and I try to order everything on that checklist.
So would I understand you correctly to say that those orders were made based on deficiencies that were already found? Is that correct?
That's correct.
I have no further questions.
Thank you, Mr. Smith. You're excused.
Thank you, ma'am.
Unless anyone wants to bring up anything else, I want to talk about briefing.
Are we going to be talking about briefing, or are we going to be talking about proposed findings of fact and conclusions of law, or do you view those essentially as the same?
I do not view them as the same. I write up recommended decisions, and I'm talking about briefing, and I'm going to talk a little bit more about specifically what I want. And I'll get your input on this. ordinarily, I have the simultaneous filing of initial briefs by all parties and then the simultaneous filing of response briefs by all parties. What would be more useful to me in this case would be to have initial briefs filed by staff and Ms. Ashworth. And I'm not going to require Ms. Ashworth and Mr. Killinger to file briefs. I'm going to make it optional. But and Mr. Killinger, could you turn your video back on, please? Thank you. What I'm going to order staff to put in its brief, this will apply regardless of whether we have simultaneous briefs or not. And I'll put this in a written order that I will probably issue today. But the format that I want to see in staff's brief is that, for instance, you have a Roman numeral 1, and under Roman, which would say alleged violations. And then under that, for example, I would like a section on each alleged violation, identifying the regulation or statute that staff is alleging was violated, and then the evidence backing that up. And again, what would make most sense for me would be then for Rocky Mountain EMS then to file a response brief to that. It doesn't make a lot of sense for me for Rocky Mountain to file a simultaneous initial brief at the same time that staff files that brief. But I'll hear from any of you if you have objections to that procedure.
Just a question, Madam Examiner. I thought I heard you say that it makes no sense to you for Rocky Mountain to file a response, and you also said it made no sense to you for Rocky Mountain to file a simultaneous brief.
Okay, if I said it makes no sense for Rocky Mountain to file a response, that's not correct. What I meant to say is, given that the nature of this case is that staff has alleged violations, that Mr. Killinger and Ms. Ashworth have alleged violations, it makes the most sense for me for them to file their briefs first and then for you to respond, rather than you filing an initial brief at the same time they do. And my question is, does anybody object to that procedure?
I do not object, Madam Hearing Examiner, but is my response going to be limited to whatever the staff chooses to put in its brief? Or if there are matters that I believe need to be addressed that staff, for whatever reason, strategic or otherwise, has not addressed in its brief, am I allowed to add those into the response? And if
Yes,
so,
sure.
if
Yes,
so,
sure.
I presume that staff would then be allowed at least to reply to whatever I brought up that's new.
So correct. Yes, you would not be limited in your response to what is brought up in the initial briefs. And then, yes, I would allow staff and Mr. Killinger and Ms. Ashworth, if they choose to file briefs, to file replies.
Yeah, and that process makes sense to staff.
Makes sense to me
Okay.
as well.
Okay. And Mr. Killinger and Ms. Ashworth, let me just tell you, the commission in its rules of procedure has a section on briefs. And I will email that section of our rules to everyone so you can see that. it does require that for each statement of fact that you're asserting, that you provide a citation to the evidence. And that would be a citation either to the transcript, we will be getting a transcript of the hearing, or to an exhibit that was admitted into evidence. And the exhibits are attached to the transcripts. And you can obtain all that from the commission's website. So I think it's, filing a brief could be difficult for you all, for the two of you, because you aren't attorneys. So I'm not going to require you to file briefs, but you may. Okay,
If Ms. Ashworth or Mr. Killinger decide that they want to file a brief, I assume they would be on the same timeline as Mr. Borman. And I'm
Yes.
assuming that at some point, we're going to be asking the court reporter here, because we've got more than 2 days of testimony, when that transcript may be made available, and then you'll determine an adequate time following the receipt of that transcript for people to review and perform their functions?
Yeah, we'll talk about that now. My understanding is that our contract with the court reporter gives the court reporter 10 business days following the day of a hearing to provide the transcript. Kim, is that correct?
I'm doing this job for the contractor. I'm a freelancer. That's what they have told me as well.
Okay.
Madam Hearing Examiner, just a point of clarification, and this is because of Mr. Killinger and Ms. Ashworth. My experience has been that when the transcript is made available, it's actually essentially made a part of the record in this particular case, and then the attorneys would access the record. But because Mr. Killinger and Ms. Ashworth, if they're going to do this, aren't attorneys and don't necessarily have the same ability to access the record, will the reporter when the record is available, will the reporter be providing it directly to Ms. Ashworth, Mr. Killinger, myself, and Mr. Borman, so that we all have it as soon as it's available, rather than having to continually check to see when it's made available?
So I will have to talk to the court reporting agency to see whether they would object to that. They email it to me. I would have to ask them whether they object to me forwarding it to you all. But in any event, I will keep track. Usually the day after I get it, it gets posted to the commission's e-docket. So I will know. If the court reporter does not authorize me to forward it to you, I will notify you when it is posted on e-docket.
Thank you.
So I'm pretty indifferent. Well, let me say, in our rule on briefing, the rule says, unless otherwise ordered by the presiding officer, parties and staff shall have 20 days after the date the complete transcript of the public hearing is filed with the commission to file a brief. So I'm not going to allow more than that. If everybody wants to go with that deadline of 20 days after the complete transcript is filed, that's fine with me. If anybody wants to propose something different, I'll hear that now.
I'm assuming what you're talking about is the initial 20 days, which would apply to Mr. Borman, Mr. Killinger, and Ms. Ashworth, and then you're going to set a separate deadline for me, correct?
Correct.
This is Brad Borman. I think 20 days would probably be fine. It would seem like based on what we're hearing, it would seem like the transcript would be posted at the at or about the end of April.
Mhm.
And so then this would have the initial brief due probably sometime between the 15th to 20th of May. And I think that would be a suitable time frame for staff.
Okay. So I'm not going to actually put a date, a deadline for the filing of initial briefs in my order because I don't know the exact date when the complete transcript is going to be on eDocket. So again, I will let you know when I know that, and then you will have 20 days after that date to file initial briefs. So Mr. Padilla, I'm assuming you're gonna, so our rule contemplates simultaneous briefs. And it says response briefs may be filed 13 days after service of opening briefs. I'm willing to give you up to 20 if you want 20.
I think I would hope that I could get it done before that, but I would ask for the 20 days as a maximum.
Okay. And then I would say, any replies, and that would be, I'm going to say the replies are going to be limited to allegations, to matters addressed in Mr. Padilla's response brief that are not responsive to the initial briefs. And I'm going to give, unless anybody objects, 8 days following the filing of Mr. Padilla's response brief for any such reply briefs.
I think we
I
can
have
make
no objection to that.
Okay. Okay, so I think that's all I have. Do any of you have any questions, or are there any other matters you want to raise?
I have a question with regard to length. My recollection of the rule, and I'm not looking at it right now, but I think the rule specifies a maximum number of pages. And the reason I bring it up is because we're dealing with 3 separate complaints in a matter that's been ongoing since October of 2019. I really don't know whether, I think my recollection is it's a 40-page limit.
So actually, there's no limit on briefs. There is a limit on exceptions. And I'm not going to impose a page limit on briefs.
Thank you.
Any other questions?
No, ma'am.
My question is, going forward from here, was this week's hearing solely for the purpose of examining witnesses?
The purpose of, I would say it's more than that. The purpose of it was also to admit into evidence the information that I can rely on and the commission can rely on in making a decision in this case. So the only information that you should rely on in your briefs is information in exhibits that were admitted into the record and testimony in the transcript from the witnesses.
All right. Is there anywhere that I can access a totality of all the evidence that has been admitted?
Yes. So when I know that the transcript and exhibits have been entered in the commission's eDocket, I will notify you of that and I will provide instructions for how you can access that. And the evidence that I can rely on and the commissioners can rely on is the scope of that is the transcript, which reflects all the testimony from this week's hearing, and the exhibits that will be attached to the transcripts. And the exhibits are, for instance, your complaint was admitted, Ms. Ashworth's complaint was admitted, a number of other documents were admitted. And also to let you know, the process following your submission of briefs is that I write up what is called a recommended decision, in which I make a recommendation to the commissioners as to how I think they should rule in this case. And then after that, all of you have the opportunity to file what are called exceptions. I would say in regular layman terms, that means objections to my recommendation. And then the commissioners, after exceptions are filed, will decide whether to adopt my recommended decision, to modify it, to reject it. They can basically do whatever they want.
I have a point perhaps of clarification. It's my understanding, and I believe it would probably be Mr. Borman's understanding as well, that in our briefing, we're going to be dealing with the hearing from December 11 of 2020 as well. And there is an order in this case that makes that particular hearing, that testimony and the exhibits in that hearing are in fact part of this hearing, at least as I understand it. When you were just speaking to Mr. Killinger and Ms. Ashworth, you were talking only about the transcript from this particular proceeding. So I don't know whether you intend to limit the briefing of Ms. Ashworth and Mr. Killinger simply to what happened now, or to what is actually already available in transcript form from the hearing of December the 11th.
Thank you, Mr. Padilla. That's a very important point. So Mr. Killinger, I have to add to what I just said. Mr. Padilla is correct that you can also consider in this case the evidence from the December 2020 hearing, which is already on eDocket. And in my order that I'll probably issue today, I will provide instructions on how to get that. And I am not limiting the complainants to briefing only issues they raised in their complaints. I'm not limiting Mr. Borman to only raising allegations raised in staff's petition. I think it's in the public interest that both staff, Mr. Killinger and Ms. Ashworth, be allowed to argue based on all the evidence admitted. Yes, Mr. Killinger.
If I have, I was listening to the December 11th hearing. If there were inaccuracies in the testimony of one of the previous witnesses, how would I address that in my brief?
You can't. You can't raise any new facts in your briefs.
Okay.
Perhaps it would be helpful. Perhaps it would be
What's that?
helpful if you explained to Mr. Killinger how he cites, for example, that if he has particular language that he wants to rely on, he has to make reference to which transcript he's relying on, what page that the testimony is on, and what line numbers.
I don't usually require line numbers, just so Mr. Killinger, if you're relying on something said at the hearing or in one of the exhibits, you have to cite to the exhibit or the transcript and the page of the transcript.
All right, so go ahead.
If you can't do anything if you think something was said that was inaccurate at the December hearing, you can't provide new testimony in your brief to rebut that. If it was rebutted during this hearing, you can cite to that.
This was in reference to a witness that I did not have an opportunity to cross-examine, so it would probably have to be new testimony in that case. My next question is regarding formatting. Is there any way that I can get a format document or some sort of previous case that is public where I can use the format from that brief to format my own brief?
Are you talking about you just want an example of how it's done, or you actually like want a Word template?
Either way, something that shows me, for instance, in the previous exhibits with the respondents' answers, for instance, how they have the opening paragraph and how they have it laid out number by number, how they have the case number listed at the top, etc. So all of these formatting things that I have seen in a lot of these documents have been pretty consistent. Tells me that the commission likes to see a particular format. So if I can have access in some capacity to what that format is for a brief, that would be nice.
Does anyone object to me providing, and I would send this to the entire service list, just maybe 2 miscellaneous briefs from other cases that Mr. Killinger could look at as examples?
I certainly don't object.
I have no objection.
Okay.
Thank you.
And what I'll do is also I will send you the certificate of service for this case in Word form. So you can cut and paste the caption onto your brief.
And to file this, all I have to do is email it to the entire service list with the certificate of service at the end as well.
You also have to file it with our Records Bureau, and I can provide the email address for that.
All right, I believe that answers my question. Thank you.
So, and let me just say there are, in our rule on briefing, there are a couple requirements that I find are not always followed, and I'm going to waive those in this case, and I'll tell you what those are. One is that brief shall contain a table of contents with page references and a list of authorities cited. And another requirement that I'll waive is that argument regarding an issue shall include a brief statement of the position of each party and of staff regarding that issue.
And those are waived. Is that what you're saying?
I'll put that in my order.
Okay, thank you.
Anything else?
Nothing from the respondent.
Nothing from staff.
No, ma'am.
Okay, well, thank you all of you very much for your participation. Thank you, Kim. And
Thank you
we're
all.
off the record. Thank you.
Thank you.
Okay, so are we not meeting tomorrow and Friday as well?
That's correct. The hearing
We're
is
done.
over.
All right, thank you.
Thank you.
Bye.